Yesterday, Arizona Governor Brewer vetoed SB 1062, a bill to amend the Arizona Religious Freedom Protection Act. This followed a political firestorm that erupted based on a deceptive campaign by opponents to misrepresent the bill. Supporters of the bill were effectively intimidated, and most others viewed the dispute with ambivalence. Although Governor Brewer ended this particular battle, there are lessons to be learned for the future. The first lesson is to recognize that this was an ideological attack on freedom by the political left. The left misrepresented SB 1062, falsely calling it the Right to Discriminate bill. Relying on people's apathy and willingness to accept such claims as true without further investigation, opponents successfully reframed the issue falsely as one of equal rights instead of religious liberty. The United States currently has a Federal Religious Freedom Restoration Act, which was passed by Congress by a unanimous vote in the House and nearly unanimous vote in the Senate, with only 3 dissenting votes in 1993, and signed into law by President Bill Clinton, a Democrat. In 1997, the Supreme Court ruled that the law did not apply to the states or local governments. As a result of this ruling, many states, including Arizona, passed their own acts to fill the void left by the court's decision. SB 1062 would have simply amended Arizona's act adopted in 1999. The changes would have made the law more specific in terms of its definitions and established that a person whose religious freedom has been violated may assert a claim or defense regardless of whether the government is a party to the proceeding. This was motivated by the New Mexico case, Elaine Photography versus Willott, where the court ruled that New Mexico's law, which is similar to Arizona's, permitted a private party to sue a photographer who refused to photograph a gay couple's commitment ceremony. This case is now before the U.S. Supreme Court. Interestingly, the New Mexico decision is being challenged even by pro-gay marriage individuals in interest groups. Another lesson to learn is whoever controls the message wins the battle. Here are some facts. Right now, it is not illegal to deny service to someone based on sexual orientation in Arizona. SB 1062 did not make discrimination legal, which is now illegal. Only where there are local non-discrimination laws applicable to sexual orientation, Phoenix, Flagstaff, and Tucson, would SB 1062 have made any difference. The purpose of SB 1062 was to avoid the situation that arose in New Mexico in the Elaine Photography case. The New Mexico Supreme Court ruled that the state's Human Rights Act prohibits discrimination based on sexual orientation, and ruled that New Mexico's Religious Freedom Protection Act did not afford the business owner a legal defense because the act protected against government actions and did not provide a defense in a suit between private parties. Even though discrimination on the basis of sexual orientation is not prohibited under Arizona law like it is in New Mexico, the legislature sought to make clear that its Religious Freedom Protection Act provided a religious freedom defense if a person is sued by a private party. This change makes no difference outside Phoenix, Flagstaff, and Tucson, where no defense is required because discrimination is allowed for any reason, whether religiously based or not. SB 1062 does not target LGBT people. There is no mention of them in the bill. If they discussed the bill, they simply adopted the empty rhetoric of the left about tolerance and acceptance, while they assert that Christians and others are bigots. They fail to recognize the intolerance and bigotry of their own statements toward Christians. The opponents of SB 1062, however, have no evidence to show that SB 1062 will result in the kind of discrimination predicted. As mentioned, these acts have been around for about 15 years in Arizona and other states. The revision of Arizona's law would look very much like the one in Texas, and reality there does not resemble the horrors predicted by SB 1062 opponents. In weighing the interests at stake, it is important to consider that the free exercise of religion is protected by the First Amendment of the U.S. Constitution. There is not a competing right to non-discrimination based on sexual orientation, either recognized by the U.S. Constitution or under Arizona law. Therefore, the right to freely exercise one's religion has legal precedence over the interest of someone demanding a private person to photograph their gay wedding, for example. Where there is a liberty right, a person is allowed to act a certain way, but there is no duty for others to assist or facilitate that action. For example, a person has the right to free speech, But there is no duty for others to provide the means to speak, and there is no duty for others to listen. We can look at this conflict of interest in the context of abortion. In the United States, the Church amendments protect the right of a doctor to refuse to perform an abortion. A woman has no legal right to receive an abortion from an objecting physician. In the case of abortion, the Supreme Court has ruled that a woman has a privacy right to choose an abortion in certain circumstances. Yet a woman has no right to compel anyone to perform that abortion. LGBT persons without a comparable right are in an even weaker position legally to demand services. As a practical matter, patrons generally do not proclaim their sexuality upon seeking services. Also, business owners are in business to make a profit, the ability of which is directly proportionate to their ability to satisfy a demand for products or services they offer. If a business owner chooses to place himself at a competitive disadvantage by refusing to serve interested patrons, he jeopardizes his business. Therefore, a business owner who elevates the integrity of his own personal religious views over his material interests is demonstrating the importance to him of the views he holds. If one thinks that a person's own moral integrity should be sacrificed for others' welfare, then they would be rejecting the views of Socrates, Thomas Aquinas, Martin Luther King Jr., and Nelson Mandela, who were willing to suffer bodily harm rather than compromise what they held to be right. In future debates, proponents of religious freedom must show that human rights, tolerance, and respect for diversity are all furthered by religious freedom. Those opposed are the ones promoting bigotry.